You're paying the mortgage every month?
No, I paid it off with my trust fund. Any communication logs or anything. I've been trying to communicate with Microsoft and Intel, and I have a whole bunch of. Oh yes, let me go. Okay, let me go.
That's fine. I'll let you in now. We don't allow observations in Zoom. They have to go to YouTube. So let me let you in, okay?
Okay.
Okay. And then do you have a camera?
I do.
There. Okay. All right, perfect. So I know when we were here last, I had given Ms. Quinata some additional time. I know you had asked to speak with counsel. I haven't seen anything, so why don't I start with you on your ability to obtain counsel for today?
Sure. I decided, I already did everything that I needed to do.
Okay.
Sorry, can you hear me?
Yes, I can.
Okay. So I decided that I already filed everything that needed to be filed. I don't know. I can't remember first of all, I want to apologize because I wasn't feeling very well last time I was in court.
You are fine.
That's the first thing I want to say.
You are fine. You sound like you still might be a little bit sick, so.
A little bit, but I'm getting better. That's all that matters. I'm getting my voice back.
Good.
But I wanted to say that I already filed everything that I was supposed to, but I can't remember if I filed a roommate release. Matthew Posner actually moved out last year, and I took full responsibility of everything. So I did want to say that on record.
Okay.
And then I also filed a quick deed claim, and that's actually in Cowlitz County Auditor's Office already. And Eleazar signed that. And he also did a warranty deed. And so I'm not exactly sure.
What was the date that was filed with the auditor?
I have getting older. Let me put these fancy bad boys on. 4/29. And the reason being is because I didn't have the money to file the paperwork. I am a single mom, and it's just Marley and I.
Did Ms. Radecki, did you receive that?
So, Your Honor, I received some deed from her. I don't recall if that was the date. I can check my inbox, though. But there was nothing to do with her name, to the best of my recollection, on it, nor Mr. Jackson's interest conveyed to Ms. Kanata.
Okay. So it sounds like we're ready to move forward then. So Ms. Radecki, this is your motion, so I'll turn it over to you. And then Ms. Quinata, you will have the option and ability to respond.
Sure.
Okay, go ahead, Ms. Radecki.
Thank you, Your Honors. Plaintiff is Annette Jackson. We're seeking a preliminary injunction and a writ of ejectment today, so that my client can get her home back. In Washington, courts that assess a three-part test generally when trying to assess whether a preliminary injunction is appropriate. Those three prongs does the person have clear right to possession? Is there a well-grounded fear or invasion of that right? And then the third one is there continued injury resulting from defendant's unlawful occupancy? So ultimately, the relief that we are requesting today is immediate removal of defendants and any unauthorized occupants, in order prohibiting the defendants from taking, damaging, moving, or selling any plaintiff's property, restoration of any personal property that's already been taken or damaged, and then authorization for law enforcement to enforce the ejectment order.
This begins as a fairly simple motion for ejectment. Before moving forward, though, let's briefly clarify the important difference between an eviction and an ejectment.
So beginning on plaintiff's clear right to possession, plaintiff is the clear sole legal owner of the premises, pursuant to a final divorce decree entered on August 26, 2024 in Cowlitz County. The cause number was 23-002-4408. That was attached as Exhibit D to our complaint. Defendants have never had a valid lease agreement, never have paid rent or a legal right to reside on the premises. The defendants had submitted a lease agreement. They purported it was valid, but it was not issued by Ms. Jackson, the plaintiff. It was not signed by her. Ultimately, they are not tenants. The defendants entered the premises without plaintiff's knowledge or consent after she was forced to leave the home due to domestic violence. RCW 7.28 supports plaintiff's legal right to possession as the record and sole title holder and the only legal owner to the property. Defendants don't assert any valid ownership rights or tenancy. They were at best holdover licensees, but now have been trespassers since they were served with the proper notice to vacate back in February of 2025. So moving on to the the next factor, the well-founded fear of immediate invasion of the rights. Defendants remain in unlawful possession and continue inviting strangers onto the property. Law enforcement frequently visits the property. Plaintiff had visited the home in December of 2024 with law enforcement and discovered a number of concerning things, but especially highlighting missing personal property. Her dogs were locked inside the house without food or water, and there was just general disrepair and suspicious activity occurring inside the home. The continued occupation of the defendants prevents plaintiff from accessing, maintaining, or safeguarding her property, and has violated her rights as a property owner. So moving on to the third and final factor regarding the actual and substantial injury to the plaintiff. There has been ongoing economic and personal harm that the plaintiff, Ms. Jackson, has suffered from the inability to reside in her home. She's had to incur additional financial expenses to house herself elsewhere in the interim. Property has been missing and gone damaged inside her home, the property that's subject of the action. She does have concerns about the well-being and welfare of her animals and other personal property that she's not been able to observe in the past 6 months. And this has caused her a great deal of emotional distress, and she has safety concerns about the property and welfare of everything there. Defendant's presence is causing continued deterioration and damages, and plaintiff is concerned about further damages if the preliminary injunction is not granted today. At this point, these injuries, a lot of them are irreparable and not compensable solely with monetary damages. So regarding the balance of equities, just to touch on that for the courts may weigh hardship when considering a preliminary injunction, but only for innocent parties generally. The defendants were warned of their status as trespassers and received a 3-day notice to quit on or about February 8th of 2025, but failed to vacate and clearly still occupied the premises. They knowingly remain without rights to do so, and Ms. Jackson is entitled to recover her property back and eject the defendant immediately without further delay. Plaintiff's hardship, loss of access to the property, damage to personal possessions, possibly her animals, and an inability to exercise ownership rights far outweighs any minimal inconvenience to the defendants at this point. They've had well over 3 months of notice to vacate and have still failed to do so or show any indication that that's their intention. At this point, we believe that the injunctive relief is appropriate as plaintiff has clearly satisfied all 3 factors: the clear legal right to possession as the sole owner, that she does have a well-grounded fear and immediate invasion of that right. There's continued injury resulting from defendant's unlawful occupancy of the premises. And courts may act to preserve the status quo and to prevent loss or damage during litigation. So we're requesting the courts to grant this preliminary injunction, to grant the order ejecting the defendants from further damage. And I did want to touch too on the bond requirement for Court Rule 65B. So it does require a bond unless it's waived. We would just simply request that the court waive the bond, but if the court is inclined to issue one, that it would be a minimal bond of just $100 due to the 2 main factors of there's a lack of lawful claim or tenancy of ownership or ownership by the defendants. There's no credible risk of this being a wrongful action at this point. And also we would reiterate a request for fees and costs associated with this action. So to sum up, we are just requesting that the court grant the order for the preliminary injunction, ejecting the defendants from the property immediately and enjoining them from interfering further with plaintiff's property or damaging it, and to authorize law enforcement to remove them immediately.
As mentioned before, the legal issue itself is remarkably simple. Now we get to hear this intellectually challenged freeloader personally describe her apparent attempt to pull off real estate fraud.
Um, okay, so Ms. Quinata, go ahead. I did review your response and I did review kind of the preliminary argument that you have, or kind of the main argument, I should say, regarding adverse possession. I know that you're not doing this without an attorney, but typically adverse possession does require quite a lengthy period of open, notorious, hostile use. So if you want to start there, feel free.
Sure.
Go ahead.
Okay. Um, first thing I want to say with the adverse possession, I've had to fix the furnace. I've had to fix everything on the maintenance um on the maintenance side of that. I already mentioned that Matthew's not there. It's just me and my son. And I kind of took some notes a little bit, but basically I've been there for almost 3 years, going on 3 years. She's, I don't know how long she's lived there. When Eleazar left, and I'm not part of their divorce case, so whatever property she had went with Eleazar, and whatever property she had went with her. So I don't have any of her property. The other thing is, ADT will verify that they never came and served me. And so I actually put up ADT systems because there were people that were coming to the house, and it was just Marley and I. And so I do have that. And then I also have that I was reaching out to her and I posted notices, hey, what's going on? And that's verifiable through Woodland Police Department because they had taken some reports and had said, we seen a notice on the door, and they actually verified that there wasn't public notice on the door and on the street side, so that she could see, hey, this is what I'm doing. Where do I pay my rent? What do I do? So I started that, I think, in September, after or whenever their divorce was. I started reaching out to her, and all I got was well, I talked to, I always forget his name, the mayor of Woodland. Anyways, I was talking with him, and I said, is there a reason why all this is going on? And he said, well, she still owns the house. I go, I know, but I'm just trying to communicate with them. So he knows about the situation too. And then I also spoke with my son's advocate through missing and exploited children. I've been talking with her about it because Annette had installed cameras at the house, and that's why we ended up getting ADT. So I do have everything that is verifiable through Woodland Police Department, the mayor of Woodland, and through ADT, that I've never been served. I've never even received a notice saying, hey, new ownership. I've never received any of that. The only thing I received was an ejection. I was like, what is an ejection? I've never heard of it. So I had to do a little bit of research, and I understand what it is, but I'm not a squatter. I'm actually on a lease. I signed it with Eleazar. And I'm kind of glad I did, because that's how it started, was, that we were roommates, and then it went into this whole big thing, and I've been dragged into their divorce for no reason. I mean, I get and I understand, but I'm not part of that case. The case, like today, is just about the house. I'm on a lease. There was an adverse possession because I kept trying to reach out to her and put posting notices, and I didn't know how to contact her. Then after that, what else was going on? Basically, that's pretty much it. I mean, and then I said, and then I've got oh, that's right. I got a foreclosure notice on the door, and I was like, oh my gosh, what's going on? You know, and so then I actually submitted the information to the mortgage company saying, hey, I'm right here. What can we do? And I filed and submitted a 1099-A with them. And then that's when I asked Eleazar. He said he didn't want anything to do with that house. I said, okay, well, will you sign? I didn't know what kind of deed to sign from him because I couldn't get a hold of Annette. And so then Eleazar had signed all of them pretty much, because I put them together. I was like, I don't know, this is what the auditor's office is asking me for, but I did pay on the mortgage and the taxes. I did the last 2 years of taxes. I paid those off. And then I also did the mortgage. I have an agreement with the mortgage company. So she was already at default before I even made this decision or even decided to go into this position. So that's where I panicked, and that's where I started asking around and doing a little bit of research. And so that's where I'm at.
You're paying the mortgage every month?
No, I paid it off with my trust fund.
Quick question. When you claim your trust fund paid everything off, are we discussing an actual documented trust or another? Trust me, bro. Fantasy account?
Real.
When was that?
I submitted it with the paperwork that I gave you guys. It is, hold on. Let's see. And actually it was more than what they, hold on it. Working in this little tiny spot. So hang on. It was paid on, of course, I got a really bad copy. I'm gonna have to pull up the original document because this is really light, the one that I submitted. But if you don't mind waiting for just a moment, I can just grab my bag and pull it out. If you'd like me to grab that and tell you the date that I paid it.
Yeah, that would be helpful.
Okay, hang on just a moment. I dropped my box right before we started this, and it was with my paperwork, but the copy that I have, the hard copy, I just can't read the copy that I made you guys.
There's a 1099 that's of poor
It's
quality.
12/24/24. Sorry, I just got it.
December of 2024.
Yes.
And did you pay the $20,000 amount, or how much?
No,
did you
I paid 487. Wait, 400. Can't even read it. $418.79. I was $79.42. And then I also paid the taxes on it, and I can grab that.
So tell me the mortgage amount that you paid in total.
$418 and $70,000. Oh no, $418,079.
Okay.
Yeah.
Okay. And Ms. Radecki, your client does she agree with the fact that the mortgage was paid off?
No,
No, she does not. Okay.
that is news to me.
And I don't have proof of that in the file, Ms. Quinata. Do you have a document there that shows?
It was on the 1099 because I had to file this with the IRS, and it's submitted as an attachment.
So
It's attachment H.
I understand. So what I was telling you is you did submit a 1099 to us, but it's of such poor quality that none of the numbers are readable.
Okay.
It appears to be in handwriting. So the title of it says acquisition or abandonment of secured property.
Right.
That's not a receipt from the mortgage company that tells me that they've received payments.
I have a V and a B and a D, 1098, all of those. Which actually I've been talking with Freedom Mortgage, and somebody had submitted that some other mortgage had the deed. So I confirmed with Freedom Mortgage, and they were like, no, we still own the loan and we still own the deed.
Precisely. The lender continues to control the mortgage and deed, regardless of your questionable 1099 scheme designed to claim property belonging to somebody else.
I guess what's troubling to me is that you clearly were aware that in September of 2024, in a final divorce decree, unlike what Mr. Jackson submitted to the mortgage company and clearly just a couple weeks ago to Cowlitz County, the divorce decree did not just state that Ms. Jackson was responsible for the payments. It stated that she was given the property.
Yeah. And I'm not.
Well, hold on. So she was given possession of the property, and he was mandated to leave the property. And so first and foremost, I mean, I have some concerns about what's happening behind the scenes with Mr. Jackson towards this property that he is telling state, county agencies that he has the right to this property. He does not. And you now have received through this lawsuit proof of that. You have not been in the property long enough to obtain it by adverse possession. Even if you had met all the other factors, you're not even close, frankly, timeline wise.
Right.
So there's no question in my mind that a preliminary injunction is necessary in this case. The only question for me is if if a mortgage in the amount of $418,000 was paid,
Right.
then I would be requiring a bond of more significance. And so I guess let me hear from Ms. Radecki first, but we need to figure out if there's been $418,000 paid towards the house. Ms. Radecki, I know you've already said kind of this is news to you. What do you want me to know?
So, Your Honor, it's interesting because Ms. Kanata claims to be a tenant, yet she's also simultaneously alleging that she's paying off $400,000 to a house that she very much admits is not hers. So that information, the inconsistencies between that in itself is troubling to me. And I think that her having submitted documents and pleadings to her for both of her claims to the court is also concerning. Like I said, that doesn't make logical sense. We have no proof other than her words today that she paid off this mortgage. And again, so I would just request that the court not take that into consideration, or at the very minimum, I guess, require $100 bond rather than waiving it, because again, we just have nothing further to substantiate the fact that she apparently gratuitously made a payment of over $400,000 to a house that she knows is not hers and is not going to be hers. It was officially granted to Miss Jackson.
So Ms. Quinata, I don't want you to get the mortgage company online. That wouldn't be admissible here right now anyway. So don't do that. Here's what I'm going to do. I do think, again, I'm going to grant the preliminary injunction. I'm going to set this just 1 week before I sign that order, though. Ms. Quinata, I'm going to give you a couple days to file with Ms. Radecki by Friday proof that you've paid off the mortgage on the house. You personally have paid off the mortgage on the house. I want you to file that with Ms. Radecki in the court. And if we get that, and I agree that you've paid it off, I'll set the appropriate bond, but I am going to sign a preliminary injunction. I find that all three factors are met. There is no viable defense to ownership of this property. And I'll tell you again, I'm very concerned that there are acts of dishonesty, to put it lightly, that have happened in the last couple of weeks with the documents that Mr. Jackson and you have filed with Cowlitz County. And I'll tell you specifically what I'm referring to.
Sure.
You're here in court telling me that you paid $418,000 to the court.
To the mortgage company.
Or to the mortgage company, thank you. I misspoke. But in the documents that you filed with the court on the quit claim deed, you stated that the property was gifted to you and you paid nothing for it. And so no excise.
I didn't know what to do.
So no excise tax. So if you bought the house for $418,000, the things that you're saying to Cowlitz County and to this court are inconsistent and probably, I would say, fraudulent.
Okay, then. Apparently, she now has 1 week to organize this disaster and somehow prove that she actually submitted legitimate documents and personally paid the entire outstanding mortgage balance herself.
That the reason why I said at the very beginning that I had him sign all of them. Do you remember? I said, sorry about that. I said I had him sign all of the deeds. I had a warranty deed, a gifted. I had him sign all of them because I wasn't sure.
But you had him do that after you already knew that he has no ownership rights to that.
I did not know that. I'm not part of their divorce case.
But the complaint that you were served with has that document in it.
What date, what complaint, which one? Because I have verification that they never served me through ADT.
the one that Ms. Radecki's office filed for this case, has the
Okay.
divorce decree.
Are you talking? Okay. That's
So-
correct.
Okay.
So that
Okay,
just
again,
came to me. I'm still on a lease. That's the bottom line. I was on a lease. Before all of this happened, I
Okay.
was on a lease.
I am disagreeing with your facts that are presented to the court. So again, I'm not kicking you out today, but next
Right.
week I am going to sign it next Wednesday at 2. Are you both available to reappear on this docket?
Let me confirm.
Okay.
I am, Your Honor.
Okay.
All right, so it looks like she has a week to get her shitlings in a row and prove to everyone that she did indeed file the proper paperwork and pay for the mortgage herself.
So I have unsuccessfully sent that to her, but in essence, it's just the mortgage statement that Ms. Jackson got from Freedom Mortgage stating that the balance was not paid off, in fact.
Okay.
And I'm not sure if you, the court would like to call this in a little bit. I can email that to her right now. It's a pretty brief document, just so she has the opportunity to.
Let's do that. So I'm going to recall this case. I'll have Ms. Radecki email that document to you because it does have a mortgage statement with a current date. Looks like it claims to be from May 19, 2025, which would purport to show that it is not paid off. And that really is, as you know from our prior hearing, I'm not going to relitigate today my decision on the writ of ejectment. What I'm here to decide today only is the amount of bond, if any, that Ms. Jackson would need to post. And as you will recall, in order for me to make that decision, I wanted to know if Ms. Quinata had paid significant sums of money towards that home, in which case I would be more likely to set a bond than if not. So that's what we're going to decide today, Ms. Quinata. I know some of your filings reference some other issues, but solely in front of me today is what have you paid towards the house?
99A, which I have communication with Freedom Mortgage. And so I have that email, but I wasn't able to submit it because I just got it back. And they said that they wouldn't be able to send me a receipt of received until around the 6th of June.
So you've had a chance to review Ms. Jackson's declaration?
I have.
Okay. So I guess Ms. Radecki, I'll have you go first regarding any non-request for bond based on the facts that I asked for some more information on, and then I'll go to Ms. Quinata.
Okay. So, Your Honor, we are requesting no bond in conjunction with the writ for ejectment for the preliminary injunction. Reason being, Ms. Quinata last week indicated to the court that she paid off the balance of the mortgage in excess of $400,000. She indicated that she did this action sometime in the end of April 2025. My client, Annette Jackson, who's the owner of the property located at 124. She contacted Freedom Mortgage, who is the lender for the home, after the court hearing, and got a current balance as of May 19th, 2025. We have included that in her declaration, and she represents that that is an accurate depiction of the mortgage statement. The only change is that the loan number has been redacted, but otherwise it is a true copy of what Freedom Mortgage has given her. It indicates that there is an active balance of over $400,000 still. And this is information given straight from the lender, which obviously starkly contrasts what Ms. Quinata is telling the court last week and this week. So we would just request that the court take that into consideration, the fact that she has not paid off any balance. There's no proof to that. And in fact, the proof is to the contrary, the fact that there's still the full outstanding balance. There's a current amount due of $27,872.61. So we would just request that the court take that into consideration and not issue a bond for this matter, given that information.
Ms. Quinata, what would you like the court to know?
Well, just like Ms. Radecki said, the account number has changed. And the reason being the account number has changed is because it's mine now. I paid that off. It wasn't my fault that they lost the 1099A to give me a receipt. So that's kind of what had happened. I had mailed it in. I mailed everything in together. They lost the 1099. After court that day, I called them and I asked them. They said they lost that portion of it, so they can't give me a receipt until they receive it. So I sent it to them. But if you notice, like just like she said, they changed the account number because it's no longer under Miss Jackson. It's under my name.
Well, that statement is obviously false. Are you seriously claiming the mortgage company is challenging you in court because it somehow misplaced your fraudulent 1099 paperwork?
So the difficulty I have is under for the statement with the date of May 19th, and it says payment due June 1, 2025. It still has Ellie Easer and Annette Jackson on the mortgage statement, not you.
They probably do owe something, but I'm on a completely different account. And I don't think I should be held liable because they had misplaced it. They can't even give me a receipt for the payment because they misplaced that one form. So I did file with the IRS, the 1099A. And if you want to, I mean, I don't know how that works. I've never did it before, but I can actually probably go online and print out the IRS form that they received it. So I'm not exactly sure where you want to go with this, but it's my son and myself. And I did everything that I was supposed to do. I went to the auditor's office. I asked them exactly what I was supposed to do. I brought them in everything. They're the ones that handed me the quit deed claim and had me fill out all the forms correctly. And that's according to Cowlitz County rules. Is like whatever the auditor says is what they say. So I did exactly what they said. The house is now under my name also. And so I don't know. I'm not quite understanding why there's going to be a bond and all of this other stuff. I believe that this is a completely different matter. I think that it has nothing to do with the bond. The bond is actually supposed to be, hang on, I'm trying to go back within memory, but a bond is actually supposed to not transfer the house. A bond is supposed to be to secure the house or let me pull it up real quick. I'm sorry. Sorry about that. But the bond is actually supposed to be. You pull this up here. It doesn't. It's supposed to just. A bond's not supposed to substitute for rightful financial stakes, but it already establishes it. So I get that, but I've also put a lot of money in the house. I had to fix the furnace. There was a lot of stuff that was the I had to fix the walls, the doors, the doorknobs. I've had to change the locks. I mean, I do the maintenance on the house. I do all of the landscaping, and I do all of those things. And I've been there almost 3 years, and I'm with a minor child. So I'm not exactly sure how it is fair, more or less, to say that you're going to remove me and my son to put Miss Jackson in there when there hasn't even been anything prior to no notice except for
Yes, it is fair, because this property does not belong to you. It might be unfair if you had followed the law, signed a valid lease, and received permission from the actual owners.
Oh,
okay, whoa, what's going on here? Because my belief was I just filed everything with Freedom Mortgage and the IRS. Okay, then that was it because it comes out of my trust. Cool. I never had to worry about that before because I paid off my cars like that, and that's just how it works. So I was super confused when they said they lost that form. So I don't think I should be held responsible or liable and be removed from my home because Freedom Mortgage has lost their portion of the 1099.
Ms. Radecki, anything further?
Just a few things, Your Honor. I mean, ultimately, the facts are pretty clear. We have Ms. Kanata and also let me correct myself from earlier. I said that the payment was made in April. I was mistaken. That's the date that the deed was filed. That Elazar Jackson, my client's ex-husband, conveyed the property to Ms. Kanata, even though he clearly did not have legal title to the property. So we have that. We also have Ms. Kanata stating that she was a tenant again, and I know we're not relitigating. This is just solely related to the bond, but just for the record, I want to clarify. She indicates that she was a tenant, and then also simultaneously indicates that she's paid off over $400,000, but miraculously, there's no proof of this anywhere. And in fact, like I said, my client contacted Freedom Mortgage directly as she is a party to the loan currently. There's been no modification or change of the loan number. The loan number has merely just been redacted by myself to submit to the court. And so we have no proof that she's made any sort of payment whatsoever. She has words, and she has a 1099-A. She sent the email that she sent me it appeared to be an email draft. There was no email address, and ultimately we have no proof that she's made any type of monetary payment whatsoever, and the proof states otherwise.
Can you forward me what she sent to you?
Yes.
And like I had said earlier, my email account with Outlook is really messed up. And so I am having to scroll up. And that was actually a scanned email that I printed out from the printer. So it's not even, that's all I have right now. But if you call Freedom Mortgage, the reason why there's two different account numbers is because one belongs to Miss Jackson and the other account number belongs to me. And so either way, there's no receipt. Is the government not a valid person to file a receipt with? I filed that with the IRS. So you're saying that my receipt with the 1099-A is false.
The 1099 I reviewed was handwritten. It was not prepared professionally by an organization.
It doesn't have to be. I actually have a trust that I go through all the time.
You should probably hire someone else to manage this imaginary trust, because the prestigious legal firm of Fairy Dust, Unicorn Farts, and Associates clearly is not helping your situation.
To the credibility of what I'm reviewing in light of my concerns I already have about what has been told to different agencies as you applied for ownership of a home, that the court had already issued an order on giving ownership and possession to Ms. Jackson. That's the point I'm making today. So I'm going to take a look at this email that you sent to Ms. Radecki.
And you don't apologize for nothing. What email should I send this to?
Send it to my last name, KARM.
I just sent the email and I CC'd Miss Kanata in it as well.
All right, give me just a minute to get that in our email system. There we go. Okay. Resubmission. 1099 Dear Freedom Mortgage. Per my conversation, I understand that you need me to resubmit a 1099-A. Please find the duplicate copy attached for your records. Should there be anything more? This just looks like a screenshot.
That's what I said. All of my emails are stuck in Outlook, so I don't have anything, any communication logs or anything. I've been trying to communicate with Microsoft and Intel, and I have a whole bunch of logs that say basically I'm not able to get into my email, and so it's like kind of my answer. It's like I know it sounds like when it rains it pours, but it really did.
So here's my ruling. I'm going to sign the order on preliminary injunction per my prior ruling last week. I don't find that there's any basis based on credible evidence that a preliminary injunction is not appropriate. I have concerns about the things that are being told to the court by Ms. Quinata. but I assume she has paid some amounts of money towards the home over the period of time she's been in it. So I am going to require a minimum bond of $5,000. That'll be the value of the bond. Pretty standard minimum amount that we would require. Again, I don't, if I had credible evidence that she had paid off a $400,000 mortgage, I would be requesting a much higher bond. I don't see that. What I have in front of me very specifically is a note as of May 19th, 2025, that over $400,000 is still due and owing on this home. So that is my finding. I have signed that order. And I think that concludes that case. Is there anything else the parties need from me today?
Yeah, I just feel like the bond shouldn't take, because I am co-owner. And so, and it doesn't matter how you feel or anything like that, or anybody else feels. I filed it exactly the way Cowlitz County wanted me to file it. I don't know what's going on. I do know a little bit, but I don't try not to get into Eleazar and Annette Jackson's information or their dispute. I'm not part of that case. And so I believe that it should not be a substitute for rightful financial stakes. I feel like this is an abuse of discretion, that you're not allowing me to at least print out the IRS form that says that it's filed with them. I understand you gave me a week. I did not know that they had lost that or portion of their and it's my fault. I didn't verify. Okay, I get that.
I seriously doubt that, because the mortgage company swallowed my 1099. Defense is terrible and does absolutely nothing to improve your position.
I'm basing my decision on the preliminary injunction and the bond amount based on the credible evidence in front of me currently. The case for the underlying possession of the property remains. So this is a preliminary injunction. You are certainly free to do two things. One, you have review rights of my decision today. You certainly can file for that. You have appeal rights, and you certainly have a right to prove your case when this specific action goes to finality. So I'm going to go ahead and conclude the hearing today, but you have several avenues you can pursue when and if you have additional information for the court.
All right. The judge has officially ruled for the plaintiff. That means a preliminary injunction will now prevent this alleged squatter from damaging the property or attempting to sell off anything located there. Her questionable paperwork never established ownership, and the court clearly was not persuaded by the imaginary trust argument. If you enjoyed this courtroom breakdown, press the like button. If you did not enjoy it, feel free to hit dislike. Either way, leave your thoughts in the comments below, subscribe to the channel, and turn on notifications so you never miss any upcoming courtroom content.